I always do this. Good afternoon, Madam Chair. I want to say morning, but good afternoon, Madam Chair, members of the committee. For the record, my name is Carrie Waterland, staff for this committee. What you have before you and are considering today is S-Draft 1138.1, which is in regards to establishing a post-conviction review board and review process for early release of qualifying offenders. By way of background, in 1981, and I promise I won't go every year, but in 1981, the legislature passed the Sentencing Reform Act, also known as the SRA, which changed the way that sentencing was done by establishing determinate sentencing for felony offenders effective July 1st, 1984. The SRA eliminated indeterminate sentences and parole in Washington state, which was established, the parole board was established in 1935 with some exceptions. Your bill report does go into details of what those exceptions are, and I'll touch on those a little bit later on in the presentation. The SRA created determinate sentences within a statutory maximum, and again, those specifics on how that's calculated are in your bill report. I'd be more than happy to talk about them today, but you can also read them. Some offenders are currently eligible to earn early release for good behavior and good performance, but many sentences are currently not eligible for early release. These include portions of sentences for mandatory firearm or deadly weapon enhancements. There are some exceptions to determinate sentencing where certain offenders are eligible for review after a certain number of years. As was heard during a work session last week, I believe, from the Indeterminate Sentence Review Board, there are a few cases that the Indeterminate Sentence Review Board does review and that the legislature has given authority for them to review. They review and release inmates if the statutory criteria is met in 3 different populations. One is a pre-SRA offender, which is someone who is convicted before the enactment of the Sentencing Reform Act. The indeterminate law allowed for all inmates except those sentenced to life without parole to be considered for parole. And under this indeterminate system, inmates have a right to a parole review, but they do not have a right to parole itself. Second, the ISRB refers Community Custody Board, which are sex offenders who committed their offenses after August 31st of 2001 and who have determinate plus sentences rather than determinate sentences. And so what that means is that the ISRB holds a hearing several months before the earliest possible release date, and they actually determine when a CCB offender leaves the prison. And then the last thing that the ISRB reviews currently are juvenile board cases. That's the Miller fix that the ISRB went into. If anybody needs more information about that, I can give that to you. But if not, we'll go ahead and move on. I'm going to go into what this bill does right now. This bill does a couple different things. First, it has a legislative declaration that offender rehabilitation shall be the top priority for the Department of Corrections, and it affirms that research shows that many offenders are able to rehabilitate and reenter the community successfully and be productive members of society. It also says that there's an intent to create an independent review board to review individual post-conviction cases for potential early release. Secondly, it renames the existing ISRB to the Post-Conviction Review Board, and it moves that board from the Department of Corrections outside and into the governor's office. This board was originally independent but was transferred under Department of Corrections in 2011 as part of some legislative efficiencies when Governor Gregoire was in office. So this bill does move it back into the governor's office. It also sets and requires board members meet established minimum qualifications for education and experience, and it increases the board composition to 1 chair and 7 members, which is 8 total, as opposed to the 4 that they do have right now, each of whom shall be appointed by the governor with consent of the Senate. Third, it allows for any individual to petition the board for early release, provided that the individual meets 3 criteria. 1, they've served at least 15 consecutive years in total confinement. 2, they've not committed a disqualifying serious infraction, which is defined by the Department of Corrections in the 12 months prior to filing their petition for early release. And 3, they consent to the review of all medical records, mental health records, and Department of Corrections files. The board will review petitions and then make one of 2 following actions. 1, they will deny the petition without a hearing if it doesn't meet the statutory criteria that are set forth in the bill. If it does meet the statutory criteria, then they will conduct a hearing, and at that hearing, they will either determine whether to grant or deny the petition for early release. individuals who are determined to be indigent who have petitioned are eligible under this bill to have appointed counsel during that hearing. The board has timeframes in the bill that where they must render their decisions, and those are 60 days from either the receipt of the petition if the petition is denied a hearing, or 60 days after the final hearing date if a hearing is held. DOC has part of this process as well as the board's decision-making process, and all of those things are outlined in the bill, things that the board considers when they are making decisions. All of those are outlined in your bill report, but if you do have questions when I'm done, I'm happy to answer that. Almost done. Fourth, it allows a hearing to be conducted telephonically without the offender's physical presence at the hearing, and it requires that the board meetings are subject to the Open Public Meetings Record Act. Washington State Court of Appeals may review the granting or denial of a petition, but only if it's determined that the board failed to follow the proper procedures. Fifth, this bill gives the board jurisdiction over an offender granted early release by the board for the length of the offender's original sentence. The board shall order the released offender to serve the term of community custody under DOC supervision. And that term may not be less than 3 years, but it also may not exceed the expiration date of the original sentence that was imposed by the court. And lastly, the board will evaluate the outcomes of the early release petitions, develop recommendations around the composition of the board and the things that they do review, and submit that report to the legislature and the governor by July 1st of 2020. Of note, this act does not create a right or entitlement for anybody to be released from incarceration at the end of their term, but it does create a right to petition and, if eligible, have a hearing to determine if the early release petition is granted or denied. And this act is to be applied retroactively to all persons currently incarcerated, regardless of the date of the offense or conviction. That concludes my presentation. A fiscal note was not requested at this time, but if you do have any questions, I'd be happy to answer those.
Questions for Carrie?